Ready, start. In state of MP and others etc. V. Neelam Singh and others etc. 2009 SCC 999, the code observate that it is well settled that power of the High Court to issue an appropriate writ under Article 226 of the Constitution is a directory. Full stop. It has been further stated therein that if there is inordinate delay on the part of the petitioner in filing a petition and such delay is not satisfactorily explained, the High Court may decline to intervene and grant relief in the exercise of its writ jurisdiction. Full stop. Emphasis was laid down on the principle of delay and laches, stating that resort to the extraordinary remedy under the writ jurisdiction at a belated stage is likely to cause confusion and public inconvenience and bring in injustice. Full stop. Thus, the doctrine of delay and laches should not be lightly brushed aside. Full stop. A writ court is required to vet the explanation offered and the acceptability of the same. Full stop. The court should bear in mind that it is exercising an extraordinary and equitable jurisdiction. Full stop. As a constitutional court, it has a duty to protect the rights of the citizens, but it is to keep itself alive to the primary principle that when an aggrieved person, without adequate persons, approach the court at his own leisure or pleasure, the court would be under legal obligation to scrutinize whether the list at a belated stages should be entertained or not. Full stop. Be it noted, delay comes in the way of equity. Full stop. In certain circumstances, delay and laches may not be fatal, but in most circumstances, incoordinate delay would only invite disaster for the litigant who knocks at the door of the court. Full stop. Delay reflect inactivity and inaction on the part of a litigant who has forgotten the basic norms. Full stop. In case at hand, though there has been 4 years delay in approaching the court, yet the writ court choose not to address the same. Full stop. It is the duty of the court to scrutinize whether such enormous delay is to be ignored without any justification. Full stop. That a part, in the present case, such belated approach gains more significance as the respondent employs being absolutely careless to his duty has remained unauthority absent on the pretence of some kind of ill health. Full stop. We repeat at the cost of the repetition that remaining oblivious to such delay does not foster the cause of justice. Full stop. Such delay may have effect on others' rapid rights and may necessarily drag others into the litigation. Full stop. Para. In our considered opinion, such delay does not deserve any unanimously, and on the said ground alone, the writ court should have thrown the petition overboard at the very threshold. Full stop. Having dealt with the doctrines of delay and laches, we shall presently proceed to deal with the doctrine of proportion, which has been taken recourse to by the High Court regard being had to the obtaining factual matrix. Full stop. We think it is appropriate to refer to some of the authorities which have been placed upon by the High Courts. Full stop.